Today, we're heading into Judge Raquel West's courtroom in Texas, a place where tensions run high and every decision carries real weight. The room is charged with emotion as cases unfold, from serious charges to repeat offenders testing the limits of the law. Judge West doesn't hold back. She speaks firmly, keeps order, and makes sure everyone knows she means business. This isn't about drama. It's about truth, accountability, and real justice, delivered right where it counts.
Good morning. Good morning, Mr. Franklin.
Good morning, Judge.
Morning, Mr. Coleman. And sir, you are Ray No?
Yes, ma'am.
And Mr. No is charged with intoxication manslaughter with a vehicle and as well as driving while intoxicated with a child under 15. And what is the announcement?
Judge, we are not ready. I believe the state had filed a motion for safe P records, and I don't think we've seen those. In April, the court ruled on it.
Yeah, just a moment. I think
Sure.
it sounds vague. I did, I saw some
Cameron Gutierrez.
safety.
Oh, I see that. Yeah.
Yeah, and, let's see, I believe the court signed the order.
I did. Yeah.
Yes.
Oh, and Judge, I did get a response. I need to go back through my file. I don't want to misspeak, but I did get a response. I
Okay.
don't know that those records, after so long, were maintained. It's what my memory is.
Okay. So why don't I just do about 30 days, and then Mr. Coleman, you can check on that. Let Mr. Franklin know any information that you. Hey, y'all. Any information that you've received. Sorry, lost my train of thought. Get together, see if we can get an announcement the next court date. Thank you.
Thank you.
Mr. Price, let's see, is Chris still, Mr. Romano? Mr. Kelly, I understand you're,
Somehow.
thank you.
Thank you.
All right, so this is the bond forfeiture docket, Nisi case number 24 DCCV 1018, and I guess these are both kind of similar issues with regard to the same bonding company, correct?
I think you're right, yeah.
And then 24 DCCV 1321. Mr. Kelly or Mr. Romano, what's...
On Mr. Celestine's, and again, I think the issues are the same here, is that the defendants in each of these cases, in Mr. Celestine's case, he was ordered, I think, by the court to get a drug patch on one setting, give it 24, 48 hours, go get a drug patch, come back, or give us notice that you've done so, and for whatever reason didn't. So my interpretation of that is a bond that should have been revoked by the court, not forfeited, or left Mr. Romano and his company responsible. That was an issue between Mr. Celestine and the court. I think the issue is the same.
Well, I mean, if he...
You ordered it in court one day. He apparently showed up to court, and we weren't notified at the jail that he had to have one. So his first day, he showed up and said he needed to have a drug pack in 24 hours. It didn't get done. We didn't know it didn't get done. And so the next 4 days, we moved the hearing up, and he didn't show up to court. So that's kind of the issues on both of these.
But if I had... Did you not know about the court dates? I mean, regardless of if there's a bond violation, a lot of times what I'll do is, if it comes to my attention through Ms. Werner will get the emails from whoever it is that they're supposed to have a GPS or a drug patch, and then if I get some type of referral back from them that says either they're not wearing it or they didn't get it or they tested positive, sometimes if it's a positive, I'll at that point just raise the bond and do it at large without proper bond. If sometimes though, I'll, instead of waiting till the next court date for these violations, I'll move it up a week or two. So I guess if I moved it up, which is what it sounds like for a bond hearing, just a review to see what's going on. Are you saying you didn't know about that date?
No, we knew about the court date. What I'm stating here is when we did the bond, the drug patch was not a part of the bond that we did with the client. That was a condition between the court and Mr. Celestine on this actual situation.
Right.
And basically, What I'm saying here is some of these bond conditions are setting us up for failure. I mean, like this guy, you gave him 24 hours to get the drug patch put on. Okay. But he knows he didn't get it put on 24 hours later like he was supposed to.
Uh-huh.
So at that point, the bond should have been either at large without proper bond. I mean, even if we want to do judgment easies, they can be defendant onlys because we're the ones getting punished here for bond conditions that when we post these bonds at the jail, we don't have much to know about. I mean, the next guy violated 18 times bond conditions that we didn't know about until the day of the hearing that he forfeited on.
Young may I respond?
Yeah.
There's a couple of things. Number one, if the bondsmen want to know what conditions, what changes are being made here in the courtroom, they should attend the hearings. It's not appropriate for the court to.
Well,
take
let
on
me stop y'all.
considerations.
I think that the conversation that we need to have is probably something that we need to have maybe at a bail bond board meeting where we can address if and how those conditions can be relayed when we do them here in court to you guys. But the thing is that's every court does it differently.
Yes, ma'am.
But the court date and the bond forfeiture, it is what it is. I mean, they didn't show up. You're not saying you didn't know about the court date. And so I think regardless of why I set something, whether it was because of a bond issue, that to me, we're talking about two separate things. Somebody didn't show up for court because of violation of a bond condition, but they didn't show up for court. So that's a forfeiture. If I know, it's just different on how, it depends on, for me, how I handle them. And we can talk about that later.
So on the next one, the state even filed a motion to increase or revoke. We set a hearing for that. He had violated 18 times. We didn't have any notification from the ankle monitor business. And we have no grounds to drop him when he is violating those conditions.
No, I understand that y'all might need some type of, I understand.
So I'm asking some kind of relief because this next, I mean.
Well, I don't know that I knew someone violated 18 times.
I didn't say
because,
you did.
No, I'm just saying I don't know that either of us
Yeah.
knew that. Because if someone's violating an ankle monitor 18 times, typically it's going to
Somebody's-
immediately be at large without proper bond, not just let's reset a hearing for a week out, because I would be concerned about that. So sometimes we may not get it from the company until they say, oh, look, there's been a whole lot of these. And so we don't know that either. So that's obviously something we need to take up. I guess,
John, if I might respond.
yeah.
Section 2213 does not list the court changing bond conditions as a grounds for exoneration on the bond. I mean, it's simply not there. I mean, it's the court has to address the defendants as the defendants appear in the court. The bond conditions for the jail. Right now, Mr. Romano has not told the court that they can't go over to the jail and pick up a copy of the conditions that are placed on them at that time. I don't know why they're not getting communication from the
Well, no,
ankle
he's
monitors.
getting them. They're getting them
It's fixed.
when they're initially done.
Yeah, it's fixed now. That issue.
That's been,
Okay.
yeah, we've been working on that.
Otherwise,
But
they
what
can
he's
attend
not getting is their information here. And I understand that they can't also be in every court every morning. There's, I don't know how many people they have working for them, but we've got 4 or 5 courts going on. So I understand that there's an issue potentially with getting that information. I don't think it changes legally, though, the fact that there was a court date, knew about it, the defendant didn't show up for that court date. And so I don't think legally there's relief necessarily that I could give unless there's some agreement to that. I do understand where you're coming from, but I think the fact that y'all knew about the court date, there wasn't some communication issue with knowing that he had to be here, or both of them were guys, that they had to be here, and that it didn't show up. I understand what you're saying. If you knew that there were those violations ahead of time, maybe y'all would have filed an AFRS or whatever.
That's part of what I'm saying is we can't. We do bail bond agreements with these people, and it spells out what grounds we have.
Right.
So these violations have to come from the court as far as the issuing of warrants, and I can't even go rearrest them. We have a investigations company, but I can only go pick up on our forfeitures. So even if we do it at large, my hands are tied on some of this. And Mr. Price just wants us to keep going after these people, and I understand that. But even on this kind of situations, I can't go after these people. I can't even issue a warrant. Well, legally, I cannot, because they could come back at us and go, well, here's what our contract says. Well, the bond conditions were not part of our bail bond agreement.
Well, what if, we need to talk about that later too. Make a note, because why can't y'all put in your bond agreement that it's any bond conditions that are there and any bond conditions that the court orders?
That would be something we have to do after the fact. So sometimes, like now, we're knowing bond conditions. This isn't an issue that's going to keep coming up because they fixed it at the jail. But this is some of the old stuff that we didn't know until we get blindsided. Like,
So were these my conditions on both of these, or were these conditions that were, because I think that is different. If these were conditions that were placed by the magistrate at the jail, or were these conditions that were placed on them here in court by me?
I'm sorry, Judge, on Mr. Celestine, I believe that was the court's
Yeah, of course.
on the drug patch.
Okay.
These were the court's standard conditions because they're
One's a
general
felony.
violations anyway.
Mr. Ortiz, I think, is going to be yours also.
Okay, so these weren't the jail issue. Okay, all right. Then I'm going to grant the forfeitures in each case, and then we can discuss somehow, if you gotta get with all the courts though, to figure out a way to get bond conditions that are placed on them after the fact by the court, which happens all the time. And so I don't know, really, other than y'all being here, but we can try to work something out. But I don't think that's necessarily the issue's going to be getting everybody to do it the same. But we can talk about it at bail bond board. All right.
Your Honor, just for clarification, I would ask that the court take judicial notice of the court's bond forfeiture docket for the cases thereon,
We'll do so.
and take judicial notice of the bond forfeiture case and the underlying criminal case in each of those,
We'll do that as well.
and enter judgment according to the court's docket.
I will do that as well.
We have final judgments prepared for that, Your Honor.
Okay. Thank you.
Thank you, Your Honor.
All right. And hey, remind me, and we'll try to figure something out. All right.
If you enjoy watching real courtroom moments and honest breakdowns of what really happens inside, don't forget to subscribe to the channel. Tap that notification bell so you never miss a new case, a sharp judgment, or a powerful moment of truth. Stay tuned. There's plenty more real justice coming your way.
See, Mr. Parker, you have Jeremiah Davis. Good morning, sir. Are you Jeremiah Davis? And this is 250066, and Mr. Davis is charged with assault on a peace officer. And what is the announcement?
Your Honor, we're asking for a little more time. We have an offer on the case, and he wants to bring me some discovery that he thinks would help the prosecution
Okay.
make a different evaluation. And so I told him he needs to call me this week and make an appointment. He's called me before, but I think he's just been able to get this
Okay.
information.
Mr. Smith, any issue?
No.
All right, so Mr. Davis, I'll reset your case about 30 days. Make sure you get that done early on. Don't wait till the last minute before court, so Mr. Parker can get what you have. He can get it to Mr. Smith, and then we can see where we get it the next court date. All right, you're free to go, sir. And then you've got Aaron Shetley.
Rejection.
Joseph.
Good morning, are you Aaron Shetley? Mr. Shetley, in cause number 240776, you're charged with a third-degree felony offense of assault family violence by impeding breath or circulation from October 22nd of 2022. And what that means is that if you go to trial and you're found guilty, the range of punishment would be a minimum 2 years up to 10 years in prison. Do you understand? And I have here on the tablet a plea bargain rejection that you've signed with Mr. Parker. This shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 2-year deferred probation. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial? All right, and Mr. Parker, you're hired, correct?
Yes, ma'am.
All right, Mr. Parker, we'll begin preparation for trial, and we'll get it set on the next available trial docket.
One thing, Judge, just, I think I have all the discovery that I need to confirm. In the discovery, it references a flash drive that was provided to the Groves Police Department. And I don't know if that's some of the discovery I have, or if there's actual flash drive that I need to get a hold of. And
Okay,
one other thing
perfect.
is the photos, if I can get it, yeah, because the computer doesn't show.
Okay, perfect. All right, thank you. Stay in touch with Mr. Parker. He'll tell you when you need to be back.
Yes.
See, Mr. Wilkerson, you have Charles Young.
He's sitting right outside.
She'll get him.
Okay.
And you have a tab. Are y'all working on something?
No, this is mine. It's,
Oh, okay.
I'm trying to go to an electronic format rather than hauling all that
Yeah.
stuff around.
Good morning, sir. You're Charles Young, and this is 250102, and you're charged with burglary of a habitation. And Mr. Wilkerson, what is the announcement?
Judge, we're going to ask, I'd like to request one more announcement setting. Still working on some information, and there's some additional information also that I need from the DA's office.
Okay. Has there been any issue with regard to bond conditions, Ms. Malfino? No, Your Honor.
Well, if you recall, there was a hearing.
Yeah, that's what it
with regard
meant.
to that matter. I'm still trying to get the evidence behind that hearing. So, in terms of what was alleged, like pictures, screenshots, messages, anything related to.
Uploaded all that discovery last week.
Okay, all right, sounds like it's all been
And a lot
uploaded.
of that, has, just so the court is aware, has come from the complainant calling the front desk, making a report to Renee, who then reports it to me. I just filed that motion not to be punitive against the defendant, just to make sure the court was aware so that there could be a no contact for both of the parties either way. And everything that I have to discuss.
Perfect. All right, so Mr. Young, I'm going to reset your case about 30 days. Make sure you stay in touch with Mr. Wilkerson so we can try to get an announcement at the next court date. All right, thank you, Mr. Wilkerson.
Y'all have a good day.
Thank you, you too. Let's see, is there a Mr. Vallis? Mr. Simmons? Good morning, Mr. Simmons. I'm sorry? Yes, on Shahram Omid. Good morning, sir.
Good morning, Your Honor.
Good morning, sir. Are you Shahram Omid?
Yes.
And this is 241684. Mr. Omid is charged with solicitation of prostitution, and it looks like there was an application for pretrial diversion.
Yes, Your Honor. We've
What's the
submitted that.
Uh-huh.
We haven't got a return, Your
Okay.
Honor, but we are willing to set this case for plea in the event it doesn't come back favorable to my client.
Okay, so what I'll do is one more reset. Mr. Smith, would you please get with, I guess, Mr. Canal or whoever is doing those up there, and if so, we can get an answer before that next court date.
Yes, ma'am.
That way you can get an answer either way. It'll get taken care of either
Yes,
with the
sir.
pretrial or with the plea on that next court
Thank
date.
you.
Thank you, sir. Stay in touch with your attorney. He'll let you know when you need to be back. And if it does get accepted, there will obviously be some other things where you'll need to go sign contracts and things like that. So if he gets accepted and the contract signing is after our next court date, y'all let me know. I'm not going to make you come. You don't have to come here.
Okay.
So we can reset it till after that to make sure all that gets taken place and
Yes, sir.
taken care of. Okay.
Okay.
So just keep us. We'll set it for 30 days, but let me know where things stand.
Okay.
Thank you.
Thank you.
All right. You're free to go, sir. Mr. Schlander, you have Celine Reinhardt.
Yes, ma'am.
250089. Good morning.
Who was gonna get it? I didn't have it.
As long, you can email it to one of the clerks this afternoon. Well, did you look at it through the portal? It's on there.
I just don't have it in file. I don't know how to get it. Philip said he was gonna get it. Somebody's gonna bring it down. I'll get somebody to do it for me.
All right. As long as just get that to us by the end of the day. Thanks. All right. And so are you Celine Reinhardt? And will your client waive the formal reading of the indictment?
She will.
Ms. Reinhardt, you're charged with the second-degree felony offense of assault on a peace officer from December 22nd of 2024. And how do you plead to that charge? Oh, I'm sorry. Yeah, I see now. Hold on. Y'all are going on a lesser included, Class A.
Position arrest.
Okay. Give me a second. All right, so in 25-0089, the state has elected to proceed on the lesser included offense of a Class A misdemeanor resisting arrest from December 22nd of 2024. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Shalander?
Yes,
Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 1-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? And are you a U.S. citizen? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Reinhardt is not competent?
No, no.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 1 year. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do all of that, then this is a great opportunity because you don't have a conviction on your record. And at the end of the probation, if you're successful, the case will be dismissed and you'll never have this conviction. The other side of that, though, is if you violate any condition of your probation, you can be brought back into court and you could be found guilty of the offense and sentenced to the Jefferson County Correctional Facility for a period of up to 1 year. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom, and the probation, she's at that desk right there. She's going to call you up in a few minutes to go over your paperwork. And you're going to help get that attachment?
Sarah's going to email it.
Okay, thank you. All right, thank you.
Well, I could do it.
That's between y'all. It's your job, but if he's going to do it, then it just has to be done today because once the case is closed out, you can't get...
This courtroom session under Judge Raquel West in Texas brought a range of powerful moments that showed the true meaning of justice, balancing fairness, accountability, and the chance for redemption. The first case involved Raynaud, facing the serious charge of intoxication manslaughter. One reckless decision behind the wheel cost a life, and the courtroom felt the weight of that reality. Judge West spoke firmly but with control, reminding him that regret alone isn't enough. True remorse requires responsibility, and when someone's life is lost, the law can't afford what IFS. Every word she spoke carried both compassion and consequence. Next was Mr. Celestine, appearing over a bond forfeiture case. His story was one the judge had heard too many times. Missed court dates, failed drug tests, and one excuse after another. He tried to justify his actions, but Judge West quickly made her point clear. The justice system gives chances, not endless ones. Every missed appearance is a broken promise to the court and a step further from trust. Then came Mr. Romano, representing a bond company court in another forfeiture dispute. Judge West didn't hesitate to press for answers. She asked whether the company truly followed through on its legal duties. Signing a surety, she reminded everyone, isn't just a formality. It's a legal commitment to ensure someone shows up in court. Mr. Kelly soon followed, echoing similar issues on behalf of another bond company. Judge West held both sides accountable, pointing out that negligence, whether from defendants or sureties, wastes valuable time and public resources. Professionalism, she stressed, must always come before excuses. Ortiz's case continued the theme, another bond issue that showed how ignoring paperwork or deadlines can quickly turn into serious legal trouble. Judge West didn't need to raise her voice. Her calm, steady tone was enough to make the point clear. In her courtroom, organization, honesty, and respect for the process aren't optional. They are the foundation of justice. The tone shifted with Jeremiah Davis, charged with assaulting a peace officer, a felony that could shape the rest of his life. As the facts came out, the room grew tense. Judge West looked him straight in the eye and said what few judges ever do. Anger has no power here, and emotion will never outweigh the law. It was a moment that silenced the entire courtroom. Aaron Shetley's hearing followed, quieter but just as serious. Already on probation and facing a third-degree felony, she stood before the judge knowing she'd fallen short of her obligations. Judge West reminded her that probation isn't punishment, it's a second chance, a rare opportunity many waste by thinking the court won't notice small missteps. But in her courtroom, details matter, and accountability is non-negotiable. Next came Charles Young, facing charges of burglary of a home. His defense asked for leniency, but Judge West wasn't convinced. She made it clear that crimes against property affect entire communities, and while rehabilitation is important, justice must come first. She values honesty and humility far more than practiced apologies, and she can tell the difference. Then there was Sham Omid, charged with solicitation. He entered quietly but left with a lesson that would stay with him. What may seem like a small offense can carry lasting social and legal consequences. Judge West reminded him that character is shaped not by mistakes, but by what a person chooses to learn from them. Her words were calm, yet they carried more weight than any sentence could. Finally, Celine Reinhardt appeared before the bench for resisting arrest and evading. What began as a moment of defiance had turned into a record that could follow her for years. Judge West broke down her behavior step by step, showing how one rash decision can undo months of effort and trust. By the end, Reinhardt's tone changed. The message had reached her throughout every case. Judge Raquel West remained steady, fair, and fearless. She held her courtroom with discipline and empathy, reminding everyone that justice isn't about punishment alone. It's about taking responsibility and facing reality. When you stand before her, excuses end and truth begins. That if this breakdown gave you a clearer look at how justice really works, be sure to like this video, share your thoughts in the comments, and subscribe for more real-life courtroom moments. Judge West's courtroom is never predictable, and that's exactly what makes it worth watching.